right, well, welcome to the Sexual Harassment Prevention and Response Training. We're going to be talking about the topic of sexual harassment in workplaces, a rather timely topic these days, and we're going to be talking with a focus particularly on prevention, how employers can respond to this, how employees can respond to it, individuals can respond to it. We're also going to be talking about the history of this law, how it came to be a law, the rationale for the law, and of course the focus is on prevention, and prevention is what this training is about. Every time we prevent sexual harassment, we prevent damage. Once it happens, there's going to be damage. Who gets damaged and how much varies from case to case, but you know, sort of like once the toothpaste is out of the tube, you can't get it back in again, and what we're here to do is keep the toothpaste in the tube. So just in reference to how sort of how much in the news this topic is these days, this is a Person of the Year for Time magazine, is basically the silence breakers, the Me Too movement. We are in a period of time right now of raised awareness, raised consciousness about this. That happened before in this country in about 1991, and I'll talk about that in a moment. And in 1991, we saw a dramatic increase in the number of sexual harassment complaints in workplaces all around the country because of something that was going on in the news at that time. We are in another such period now with several very high-profile cases coming forward. A lot of the cases that are coming forward are focused on a type of sexual harassment called quid pro quo, which involves an abuse of power, and we are going to talk about that type of sexual harassment, but we're also going to talk about a much more common type of sexual harassment called hostile environment that does not necessarily involve power, but it does involve behavior and comportment in the workplace. So defining this is one of the problems. One of the reasons it's problematic is because it's not something where there's a concrete, static definition. I can just point to a list of behaviors and say, don't do this, this is sexual harassment. There are some variables here, some moving parts. And so you look at our definition here, it says sexual harassment is any unwelcome sexual advance or conduct on the job that creates an intimidating, hostile, or offensive working environment. The key word here is unwelcome. A lot of times when people give me an example of some behavior they witnessed or took part in a workplace and they ask me, is that sexual harassment? My answer starts with two words, and the two words are, it depends. And that word unwelcome is what it depends on. So it isn't always about what behavior a person engages in, but whether or not the behavior is welcome. And it's important to know that we don't always know that. We don't always have a knowledge beforehand about what's welcome and what's not welcome. So this really calls on us all to make judgments, to make decisions about what we're going to say and how we're going to behave in the workplace. And these are judgments and decisions we didn't have to make 30 years ago. We do have to make them now. So that's a very key word here, unwelcome. Now, if you look further in the definition, sexual advance, well, that's a pretty specific kind of behavior. It's a sort of narrow thing. A sexual advance is an attempt to seduce or quote-unquote hit on somebody. So that's a fairly narrow bit of behavior. And then what immediately follows is much more broad, or conduct on the job, conduct of any sort on the job that creates an intimidating, hostile, or offensive working environment. Environment is another key word. Under the law, there are two different kinds of sexual harassment. I already referenced quid pro quo. That's a Latin phrase. The translation of it is this for that. This is the kind of sexual harassment that's very much in the news these days and, like I said, involves the abuse of power. Quid pro quo sexual harassment can only be perpetrated by someone of superior rank against someone of subordinate rank. It is a blatant abuse of power. If you want this job, you must do this sexual thing for me. If you want this promotion, if you want this schedule, if you want that vacation day, whatever it might be, that salary increase or whatever. In our experience in the employee assistance world, we don't see quid pro quo anywhere near as often as we see the other type of harassment, hostile environment. And the reason we don't see it as often is because the pool of candidates who can perpetrate it is, by definition, much smaller, only people with power. However, when we do see it, it is extremely damaging. It has a tremendous amount of impact on the organization and a tremendous amount of impact on the victims. Usually somebody's career ends, at least one. Oftentimes an organization takes a big sort of public black eye when this happens, and it's extremely damaging, but not anywhere near as common as hostile environment. Hostile environment sexual harassment can be perpetrated by anybody. It's not necessarily about power. It can be a colleague, it can be a superior, it can be a subordinate, it can be a visitor, a vendor, a customer, a contractor, anyone that you deal with in the process of making a living. And hostile environment usually involves more than one occurrence. And I'm trying to be a little careful when I talk about this because it is possible for only one occurrence to be sufficient to create a hostile environment. But typically, an environment is created by a pattern of behavior. So the law has a little bit of flex in it, a little bit of forgiveness, allowing for the fact that we're human and somebody might in a given moment say something socially inept or awkward, and they apologize and don't do it again. It's kind of hard to make the case that that created an environment. But patterns of behavior, repeated behaviors definitely do create environments. So this is the definition that we use these days. This is sort of how we try to capture it. And like I said, there's a lot of moving parts here. It's a very broad sort of area with lots of considerations, and of course, this idea of welcomeness, which is a variable. It's not the same in every case or in every workplace or with every person. And when we talk about sexual harassment, it's very important to keep a focus on the impact. One of the questions you sometimes hear is, can somebody file a sexual harassment complaint against me because they don't like me, or they want to get back at me for something, or they're competing with me and want to hurt my reputation? Theoretically that could happen. Practically, in the experience we have at the Employee Assistance Program, almost never happens. In fact, the opposite happens. Filing a sexual harassment complaint is not easy. There's impact. There's impact of the harassment, and then there's impact of filing the complaint. These matters affect people in very profound ways. One of the questions we also sometimes get is, why did so-and-so wait 10 years to come forward or 5 years to come forward? And I think if we go through this list of impacts, you'll see why somebody might have a reluctance to come forward. And please bear in mind that we're not talking about this to discourage people from filing complaints, but we're trying to make the point that people don't do it frivolously. And we try to especially emphasize the point for people in management that if somebody does come to you with a complaint, it's really important to take it seriously. You can probably assume that that person has been down a lot of miles of bad road before they made this decision, because it's a risky decision. Even when your complaint is righteous, you pay a price for filing a complaint. One of the ways you pay a price when sexual harassment happens is the effect that it has on your personal relationships. People have husbands and wives and spouses and relationships like that. Talking about some kind of sexual behavior in the workplace could have a really negative impact on someone's personal relationships. And it's one of the reasons why people don't bring it up necessarily. Or if they do bring it up, these areas are affected. Certainly psychological ramifications. This is very personal, very private, and in many cases there can be a history of trauma. People can have had previous experiences, and so experiencing harassment, talking about harassment, being around harassment, watching harassment, witnessing it can trigger people and push buttons for people. It can put them in a state of great distress. And let's not underestimate people's careers, the impact that such a complaint can have on a career. You know, theoretically, we'd like to say that it has no impact. And in theory, that's a great theory. In actual fact, think about it. You know, if somebody files a complaint against a supervisor and then they get transferred to a new supervisor, don't you think the new supervisor might have some, like, you know, when is this person going to file a complaint against me? And so those kind of things, that sort of reputation, that sort of identity does follow people around. It's not fair, it's not right, but it's one of the reasons why people are often reluctant to file a complaint. I remember talking one time to a woman police officer who had been a police officer for 17 years and revealed to me that she was a victim of sexual harassment for all 17 of those years. And I asked her why she didn't file a complaint, and she said, because I love my department, I love my job, I love my career, and I would have been perceived in this profession as weak for filing such a complaint, and that would have had an impact on my career. So this is the reality. This is the reality of what weighs on people when these sorts of things happen. Loss of relationships, and we'll talk about this in a little more detail, but one of the things that's really hard to do in a sexual harassment matter is to keep it private. And so colleagues find out that somebody filed a complaint. And a typical group dynamic that emerges in the aftermath of a sexual harassment complaint is the group splits in two. Half the group supports the complaining party and half the group supports the accused party. So you can imagine you go file a complaint and then go back to your work group and find that you've lost half of your friends. Unpredictability of the outcome. You may have a righteous complaint to make, but if the investigation that follows does not, you know, produce or uncover evidence that supports your complaint, there may be a finding, what they call it no finding. The result is they call it no finding. So you've made a complaint and gotten sort of nowhere with it, and that's a possibility whenever somebody files a complaint. It's not a guarantee that there'll be justice at the end of that road. You don't get to control the process. So going back to that previous scenario, you know, when you go back to your work group and find that half your friends aren't talking to you, so now you go back to your boss and say, listen, I want to withdraw the complaint. This isn't worth it. Well, guess what? You can't do that. Once someone in management becomes aware of harassment occurring in a work setting, they have to assume that there's more than one victim. You may not be the only victim. And if an employer sits on, hides, or doesn't respond to known harassment later in a court proceeding, that can emerge, and we've actually seen supervisors lose their jobs because they did not respond to complaints. So even if the original complaining party wants to withdraw the complaint, the investigation has to go forward anyway. There's a loss of privacy. Again, these issues are intimate, personal. People like to keep it private. It's very hard once an investigation is underway for people to keep it private. And so there's a bit of a loss and a bit of an exposure that happens. And again, the idea of triggering memories from past experiences, that can be extremely traumatic and distressing for people. So this is, you know, when we talk about the impact on victims, let's not underestimate it. It is very, very difficult for people to lodge complaints and sort of stay with the complaint all the way through to the end. And that's why people sometimes wait. That's why people sometimes are reluctant. And sometimes people don't file complaints. And again, we really want to make the point that if you're in a management role, any kind of leadership role, and somebody comes to you with a complaint, it is in the best interest of everybody to take that complaint very seriously and make sure a good investigation follows. Even, you know, if we get outside the whole idea of lawsuits and jury awards and that kind of thing, the impact of harassment on a work group, certainly morale is impacted. People may get a sense that, you know, we got this kind of stuff going on here in my workplace. You know, maybe I'm not so safe here. Maybe it's not such a good place to be. Maybe I don't trust management as much now because I thought you guys were supposed to kind of be on top of this stuff, and now this is happening. And Certainly unity is affected and impacted. That whole thing I talked about where the group splits. Half the group supports the accuser and half the group supports the accused, and the unity of the group is thereby impacted. Productivity. Once something like this happens in a workplace, there's two ways productivity is impacted. More than two, but two that I'll talk about right here. But, one is people are thinking about this. People are talking about this. People are paying a lot of attention to this, and therefore paying less attention to work. There's also an investigation that has to happen, and an investigation usually involves interviewing people. So instead of you working for the next hour, I got to take you into my office and interview you. So we lose that labor of a half of an hour or whatever amount of time. So there's a productivity decrease, not to mention when people's morale is low, their enthusiasm goes down, the energy that they put into the work is not as high. It can actually become hard to hang on to good people. When a workplace has a reputation as a place where people are not respected, or it's not safe, it can affect retention and it can affect recruiting. And in some workplaces, in some companies, particularly companies that have to be aware of maintaining a good reputation, or they lose customers. Customers make decisions based on the reputation of an organization. So you can imagine if I'm about to put my mom into a nursing home, and then I read in the paper that there's a big sexual harassment thing going on at that nursing home, I might have second thoughts about putting my mom there. I might go to some other place. And so you can lose business and status as a result of these sorts of things, not to mention the lawsuits and the jury awards and the other things that sort of go along with this as well. So let's take a look at some of these behaviors. And we just, this is not an all-inclusive list of behaviors that come under the heading of sexual harassment, but these are some of the things that we see in workplaces. So we know, for instance, that people tell jokes at work. And sometimes people tell dirty jokes, sexual jokes, or ethnic or racial jokes. So the question is just a sort of rhetorical question. How comfortable are you personally with that kind of humor? And can you think of somebody in your work group whose comfort level is different from yours? And that's the operative principle here. Not everybody has the same level of comfort with behaviors. The use of endearing names, calling somebody sweetheart, calling somebody honey, baby. Now people say, is that always sexual harassment? No, it's not. Some people find that really friendly and warm. In certain parts of the country, it's almost as common for people to be referred to as sweetheart. But you got to understand what a workplace is, and one of the things that a workplace is it's a competitive arena. It's a place for people to come and do well and work well and be noticed and be perceived a certain way and hopefully succeed and advance. So if somebody's ambitious and somebody has a certain idea of how they want their career to go, it may be very much in their interest for other people to see them as a serious person. And here comes somebody calling them the same name as you might call a puppy or a 6-year-old. You can see how that might diminish the person's status or how the person is perceived. So the point here is that people need to be called what they want to be called in the workplace, not what we decide to call them. Going back many years, my own personal experience working in factories back in the early 70s, I clearly recall almost every factory I worked in, there was usually an overweight guy that they called Tiny and a bald-headed guy they called Curly. And you see what I'm talking about here. People got nicknames based on their appearance. I remember one man in particular whose nickname was based on his race. He was African American, and the name they gave him had nothing to do with his own name. It was strictly racial. Those days are gone. We can't do that kind of thing anymore. What about like swearing, cussing? How often does strong language fly around in your work world? Different workplaces have different cultures, different sort of expectations around this, and we're not trying to be language cops here, but I think it behooves us to remember that not everybody is equally comfortable with strong language. It varies. It varies by culture, it varies by religious background, it varies by age, and certainly it varies by gender. again, you can think of exceptions, but in our culture generally, women are less tolerant or comfortable with strong language than men are. That brings up a point. There's a thing in sexual harassment law. Whenever you have a behavior or a law that's sort of trying to capture things that are a little bit vague, the legal profession has these standards that they come up with, and a very common standard, and the standard that used to apply in sexual harassment was what they called the reasonable person standard. So if you were pursuing a case in court, you would have to convince the court that a reasonable person would have found the behavior intimidating, hostile, or offensive. And about 20 years ago, a new standard was coined just for sexual harassment. And that is the prevailing standard now, and that standard is referred to as the reasonable woman standard. So that cultural difference between men and women is reflected in the law. Talking about how people look, there's a certain continuum here. You know, telling somebody, I like your new glasses or I like your haircut, you might be okay with that. Making any kind of negative statements about how someone looks, or getting a little too personal and a little too descriptive, like, you know, that dress really shows off your shape. Are you losing weight? You look great. That's when we start to get into that area where not everybody is going to be comfortable with that. So it's a risky slope to be on, and it's one where people need to be careful in workplaces. Also in workplaces, people have all kinds of conversations. You know, people talk about sports, people talk about politics, people talk about weather. Sometimes people talk about work, and sometimes people talk about sex. We're adults. Sometimes adults have adult conversations. So that topic comes up among a group of adults, and it starts out as an appropriate, sort of comfortable conversation. And, you know, we're not here to tell you not to be adults. And I'm also not telling you to run away from those conversations. But I can tell you some experience. And the experience I've had is on at least 2 occasions I've had people referred to me who've been accused of harassment because they took part in a discussion like this. And because that topic was on the table, they assumed that all the boundaries were gone, and they blurted out something really offensive, and then blamed the others for bringing up the topic. So what I suggest to people is when that topic comes up, it's not a time to be less careful, it's a time to be more careful. Asking a colleague for a date, it's an interesting area here. The sexual harassment law does not prohibit workplace romances. Some companies do. Some companies have policies about that either limit, restrict, or forbid that. But the law is silent on that. Asking a colleague for a date is not sexual harassment unless the colleague says no and you keep on asking. Okay, so these are just some of the behaviors that come under the heading of sexual harassment. There are others. This is not an all-inclusive list, but it's just I want to get you kind of thinking about this, and this is the kind of judgments we have to make on an ongoing basis. I remember talking to an attorney one time who told me that the hardest kinds of cases to defend are cases that involve unaccidental touching. So you think about this in the workplace. You know, what the most common way that people touch each other in a business setting is the handshake. I don't know if you ever noticed this, but some people, when they shake your hand, they just have to touch you somewhere else, or they do a two-handed shake, or grab your elbow, or touch your shoulder. Or some people are just naturally more touchy than other people. And again, that's not always harassment. Some people find that friendly and charming, but other people can find that quite intimidating. So unwelcome touching is always risky and very, very hard to defend. The workplace hug, the embrace. Again, we're not telling you not to do that kind of behavior, but you remember the welcomeness standard. Make sure you know for sure it's welcome. Don't make assumptions about that. Along with touching also comes another related sort of issue, and that I guess the comedian Seinfeld used to call this close talkers, people who don't respect the concept of personal space. The 12 to 18 inches of space around us that is considered personal, and for some reason or other, certain people don't recognize that convention and routinely invade that space. And again, you know, we can't predict how welcome that is going to be, but some people find that extremely uncomfortable and threatening. You don't always know the experiences of the people you work with, what they've been through. So you need to be careful about making that kind of encroachment. In martial arts, closing distance is considered an act of hostility. Any kind of verbal language, use of language, swearing, offensive jokes, threats, comments, sexual suggestions, but it doesn't even have to be verbal. It can be staring at somebody, gestures, motions, cartoons, emails, screensavers, cell phone ringtones, rolling of the eyes, noises, anything along those lines can constitute sexual harassment behavior. And this slide is probably the most important concept of all in sexual harassment: impact versus intent. This is where people get tripped up. It is possible for somebody to commit sexual harassment without intending to. Under this law, the intention of the accused party is legally meaningless. The only thing that matters is the impact of the behavior. And our experience here at the Employee Assistance Program is that quite often we get people referred to us who have been found to have committed sexual harassment. And frankly, some of those people are sort of nasty or mean-spirited or intoxicated or angry, creepy. But actually the vast majority of them are not any of those things. The vast majority of them had another intention. Often they were trying to be funny. Sometimes they were trying to give somebody a compliment, trying to emphasize a point, all those intentions. And if you defend yourself, if you're accused of sexual harassment and your defense is that you didn't intend to harass anybody, that is a legally meaningless defense. The only thing that matters is the impact of the behavior. So it is possible for nice people with neutral or good intentions to get in trouble with this law because simply from not being careful and not being aware. One of the first cases I dealt with involved a man who walked up to a woman in the workplace and said to her, he's an older guy, and he walked up to a woman in the workplace and said to her, "I like the dress you're wearing today, but I really like the one you wore yesterday because that one shows off your nice legs." This was about 1995. I think we can say that most people know nowadays not to say that kind of thing to any woman in any workplace. In this case, it was a little bit worse because the person he said it to was the human resources director. And she called me up and she said, listen, I've known this guy for a long time. He's actually a very nice man. I know he didn't mean this in a bad way, but my God, if he's saying this to me, what's he saying to other people? We can't have this. And I got the guy in my office, and he was a very nice guy. And his intention was based in a sort of a set of politeness standards from like 1930. I said, well, what were you trying to do with that statement? And he said, when I was a kid, I was taught that when you interact with women, you need to tell them that they're beautiful. And I said, well, that would have worked in 1942, but it's 1995 right now, and that's not going to work. Once we explained it to him, he got it, he understood it, went back to work, and never did it again. Nobody got fired, no lawsuits. The requirement on the part of the employer is to take action to stop the behavior. So sometimes, quite often in fact, education is how the behavior is stopped. And that's one of the things we're doing here, some education so that we prevent this from happening. But I have to tell you, when we talk about impact, certainly there's impact on victims. There's also impact on accused parties. It's not a nice label to wear to be called a sexual harasser. It doesn't feel good. It certainly doesn't feel good to be harassed. It doesn't feel good to be a harasser either. A lot of times I ask these guys, what are you going to do about your relationship with the person or persons who complained about you? And the most frequent answer I get is, I hope they accept my apology. Now, to be frank with you, that they're not all nice people. And I did get one guy who answered that question by telling me he was intended to murder the people who complained about him, and he was quite dangerous and meant it. And we had to get the police involved and restraining orders, and he lost his job. And so it does run the gamut. I don't want to give the impression that only nice people commit sexual harassment, but a lot of nice people do because they don't understand the law, or they are not careful. We all are required now to make judgments about what we do and what we say in the workplace. While we're on this topic, it probably pays to talk a little bit about the history. Sexual harassment law actually grew out of the 1964 Civil Rights Act, signed into law by President Johnson, which finally made it illegal to treat people differently in the public arena based on membership in what they called protected classes. Gender was not in the original law. It was added about, I think, 9 years later. And sexual harassment law grew from that, So we have, by the early 70s, we have gender included. We did not see a lot of sexual harassment cases in the 80s or the 70s. But in 1991, like I mentioned, there's a big dramatic increase. And obviously something happened. There was a cultural phenomenon that occurred that all of a sudden brought it to people's attention. Prior to this event, most people thought that if you were the victim of harassment in the workplace, the two options were put up with it or quit. But in 1991, Clarence Thomas was nominated for the Supreme Court, and during the confirmation hearings, Anita Hill came forward and informed the Congress that he had sexually harassed her in a previous workplace. And all of a sudden, everybody got interested in that process, and it was 11 straight days, all day long on television, and everybody was tuned in. It was a hot story, a hot topic, got everybody's attention. It stayed hot even after the hearings. There was a best-selling novel shortly after that that had corporate sexual harassment as its theme, and that novel was called Disclosure, and then that novel was made into a movie by the same name. And so for a 2 or 3 year period, we were sort of bombarded with this message, and all of a sudden people understood that put up with it or quit are not the only two options. And once that happened, we all picked up a responsibility, and the responsibility was that we needed to be more careful about how we conducted ourselves in the workplace. Workplaces picked up a liability, and they needed to pay attention to preventing sexual harassment from happening. The good thing is workplaces have become much more civil, much more respectful, much more comfortable, and in fact, demonstrably safer. The incidence of coworker-to-coworker violence, which has always been low, is currently about half of what it was 25 years ago. And we think there's a direct connection between the fact that companies have policies about how we interact with each other, and they enforce those policies so things don't escalate. And troubled people are sort of taken out of the equation. And so we have much safer workplaces, much more civil and comfortable workplaces. As a guy in a workplace, and some self-disclosure, I think I'm funny, and I work with almost all women. All day long, I have to make judgments about what to say and what not to say. And I'm not complaining. That's not a burden. We all have that responsibility. I'm also a dad. I have 2 adult daughters out there in the world making a living. I'm very glad that put up with it or quit are not their only 2 options. So that's some of the history. And when we talk about this topic of sexual harassment, it pays to take a quick look at discriminatory harassment as well. Because the same standards and the same sort of approach apply. And again, the 1964 Civil Rights Act really focused on this idea of protected classes. Race, If you look at the history here, you know, there was a movie that came out a few years ago called 42, told a story about Jackie Robinson, the baseball player, who African-American, was the first African-American baseball player allowed to play in the white professional leagues. Not that long ago, if you were African-American and you were a great baseball player, you had no shot to play in the white professional leagues, and that was legal. And baseball certainly wasn't the only business or workplace or arena where that was the case. There were all kinds of avenues shut down to people who weren't white. And in 1964, that was finally addressed. Ancestry, national origin, those were actually, those criteria were used to exclude people from opportunities. There's an old sort of tradition, particularly around here in New England, back in the days when the mills ruled the economy. If a mill was hiring somebody, they'd put a sign out front, say help wanted. And they would add a phrase to the sign, and often the phrase would be no Irish need apply. Or if it was New York, it would have said no Italians need apply. So it was legal to exclude people from opportunities based on their ancestry. Religion, age, marital status. Now you notice on this list here, gender identity, expression, and sexual orientation have asterisks next to them. The reason for the asterisk is that the federal law still does not address this. It's just silent on this topic. It doesn't get into it. There are, however, a handful of states that have state laws that make it illegal to discriminate against people on the basis of gender identity or sexual orientation. And if, you know, Massachusetts, Rhode Island, and a host of other states have that written into their state laws. Disability, pregnancy, and even this idea of genetic information. Sometimes people ask what that's about. There have been a couple of cases where companies, through their wellness program, conducted genetic testing on their employees, and they found out that certain employees were susceptible to cancer, for instance, and they would let those employees go because they didn't want that expense on their health insurance, and based on that criteria, so that was quickly made illegal. And this is the awkward phrase here, protected classes. What's being referenced is the 1964 Civil Rights Act. Employers have liability here. There can be lawsuits. They're not common, but they do happen. And often when they do happen and they go all the way to trial, the lawsuits can result in awards of multiples of millions of dollars. The level of liability for the employers is quite high. It's not just a matter of receiving complaints. I have a couple of cases where companies defended themselves in a lawsuit by saying nobody told us, we weren't made aware, and how can you hold us responsible for something no one told us about? The court's response in both of those cases was, you are the employer, you should have known, and therefore the liability still exists. So it isn't enough to passively sit back and wait for complaints. Employers must actively seek out and stop harassment at the earliest possible time. And this really does start at the top for any organization. One of the first things we can talk about here is the fact that management, anyone in a leadership role, has an obligation to model the expected behavior. Because once something is okay for leadership to engage in, then it's okay for everyone. So is this added responsibility for leadership to really be very careful and very sort of serious in terms of their observation of what is expected under these laws. It's also important to vocally support the policy for anyone in a leadership role. And the reason we bring this up is, this is America. People have opinions about lots of things. And it's quite possible that someone could walk out of a sexual harassment training and say something like this stuff's going too far. This is kind of ridiculous. I don't believe in this. If you're in a leadership role and you say those kinds of things within earshot of the people who work for you, you have just eliminated yourself as a resource to those people. If something happens, they're not going to come to you. And that increases the likelihood that they will instead go see an attorney. So you want to you don't need to constantly do it, but every once in a while, just sort of bring up the topic and let people know that you support the sexual harassment policy, that it matters to you that people are comfortable and feel respected. Management has an obligation to be open to complaints, to be aware of the idea of retaliation, that sometimes complaining people can go through a tough time. So we need to keep a real close eye on the experience they're having after they file a complaint. Accountable for failure to report or act. I just got done dealing a little while ago with a case involving some sexualized behavior in the workplace. The supervisor knew about it and did not report it and didn't do anything about it. And when upper management found out, the supervisor was terminated. Anyone in a management role, if there's something going on that looks a little sexual, looks a little questionable, start working on it, start dealing with it, and do not go it alone. You may want to keep things private so people don't get embarrassed, but there is way too much liability going on here for any one manager to carry this all by themselves. So the first thing you want to do when something like this happens is get your HR people involved, get your own boss involved. Feel free, if you have an employee assistance program, call your EAP and get all the consultation, support, and help and guidance that you can possibly get. These are some reading materials that sort of we utilize to put this training together. There's a couple of articles and books and even a TED Talk that was part of this. And I just want to invite you also, if you have any questions about this topic or any reason at all, to contact the Employee Assistance Program if you feel you're a victim of sexual harassment. If you have concerns about something going on in your work group and you want to talk about it in a confidential setting, you can call the Employee Assistance Program. And the numbers are right here on the screen. Thank you so much for your attention to this very important topic, and I hope the training was helpful and instructive for you. Thanks so much.